In the last video, we talked about first two articles of Part 3, that is Article 12 and Article 13. In Article 12, we understood the definition of state, and in Article 13, we understood things related to law. Today, we will talk about first fundamental right of Part 3, that is right to equality, which is defined from Article 14 to Article 18. The first article under right to equality is Article 14. Article 14 says, the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. This whole statement contains three important points. First, any person. Second, equality before the law. And third, equal protection by laws. These three concepts defines the actual motive of Article 14. First one says, the state shall not deny to any person. It means this article is applicable to both citizen and non-citizen. Next is equality before the law. This concept is taken from the British Constitution. Equality before the law means every individual, be it Prime Minister, any Bollywood actor, actress, a person of any religion, man, woman, rich or poor, will be treated equally by the law if anyone does anything legally unjustifiable. But think for once, is it really possible to treat every individual equally? No, actually it is not possible. For example, if two people are guilty in a murder case, one of them is between 16 to 18 years of age and other is above 18 years of age, will the court give equal punishment to both? No, it doesn't happen according to our law. Because some group of people in our country are in disadvantage, like women, child, poor people, etc. According to our given example, a child should get more protection. And to meet all these shortcomings, the concept of equal protection of laws was introduced, which says that individuals in similar situation and circumstances should be treated equally by the law and discrimination should be reasonable. This concept is taken from American Constitution. Equality before law is a negative concept and equal protection of laws is a positive concept, because equality before the law tells what not to do and equal protection of laws tells what should be done. There are some exceptions of Article 14 like Article 361, Article 361A, Article 105. Apart from these exceptions, some more exceptions are there, but I am including only the important ones. Article 361 says the President of India and state governors enjoy certain immunities like no civil and criminal proceeding, not answerable to any court, no arrest, etc. during their term. Article 361A says a media person shall not go through any criminal or civil proceeding with respect to a true report published on television or newspaper related to parliament proceedings. And Article 105 gives immunity to the member of parliament from any court proceeding for any vote given in the parliament. Next is Article 15. Article 15 says, as per the constitution, there shall be no discrimination on certain grounds only. That is, religion, race, caste, sex, or place of birth. Apart from these five mentioned grounds, discrimination can be done on other grounds such as merit, intelligence, qualification, etc. It also says no person shall be restricted on access to shops, public restaurants, hotels, and places of public entertainment. No person shall be restricted on use of wells, tanks, bathing ghats, roads, and places of public resorts. There are some exceptions in Article 15. It says, nothing in this article shall prevent the state from making any special provision for women and children, and also for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. Next is Article 16. Article 16 talks about the right of equal opportunity in the matters of public employment. It means there shall be no discrimination while giving employment to the citizen of India on the basis of race, religion, caste, sex, place of birth, descent, and residence. As we are talking about public employment in India, so it is important to understand reservation and the story behind it. The most important thing related to reservation till date is the Mandal Commission, which was also known as the Socially and Educationally Backward Classes Commission. It was established in 1979 to identify and give reservation to socially and educationally backward classes of India. It was headed by B.P. Mandal, full name Bindeshwari Prasad Mandal, former Chief Minister of Bihar. If we are talking about Mandal Commission, then it is important for us to know that this commission had passed through whose governments. While understanding this, we have to remember names of three prime ministers. First, Morarji Desai, second, VP Singh, and third, PV Narasimha Rao. Tenure of Morarji Desai was from 1977 to 1979, VP Singh from 1989 to 1990, and PV Narasimha Rao from 1991 to 1996. In 1979, Morarji Desai established a commission called Mandal Commission, headed by BP Mandal. After 1 year in 1980, the commission submitted its report stating to give 27% reservation to OBCs. But few days later, due to some political reason, the government got changed. And for the next 10 years, whichever government came, they did not talk about this topic of reservation. Then in 1990, when VP Singh was the Prime Minister, the matter of reservation was discussed again. And VP Singh accepted the proposal and declared that 27% reservation would be given to OBCs. The announcement witnessed violent protest all over the country, especially in northern part of India. A few months later, a lawyer, Indra challenged the implementation of Mandal Commission in the Supreme Court. And then the Supreme Court put a stay order on the implementation of Mandal Commission, whose decision came after 2 years in 1992 when PV Narasimha Rao was the Prime Minister of the country. On the decision of Mandal Commission justifying and accepting the demand of 27% reservation of OBCs on the basis of backwardness, the Supreme Court also gave some important decisions. It said, the creamy layer, it means the advanced section among the OBCs will not get any benefit of the reservation. It also mentioned there will be no reservation for promotions. The total reserve quota should not exceed 50%. If in any year the reserved seats are not filled completely, then the remaining seats can be carried forward to the next year. But the carried forward seats should not violate the 50% rule. And this carry forward rule will be applicable only for 3 years. And also said a permanent statutory body should be established to examine the list of OBCs. Mandal Commission also demanded for 10% extra reservation for poorer section of general category, which was rejected by the Supreme Court at that time. But in 2019, Modi government talked about it again, and now 10% reservation to the poorer section of general category has been implemented. Next is Article 17. Article 17 is about abolition of untouchability. This article says untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. This whole statement contains two important points. First, untouchability, and second, offence punishable in accordance with the law. First one is untouchability. This word is neither defined in the Constitution nor in any act passed by the Parliament. This word can be understood from some of the cases in the past and their judgment given by the High Court and the Supreme Court. Jai Singh versus Union of India case of Rajasthan High Court and Devrajiah versus B. Padmana case of Madras High Court defined the word untouchability. The court said that in Article 17, the word untouchability is placed under inverted commas, which means the word is not to be taken as its literal or grammatical interpretation. The meaning of the word is to be derived from historical or past practices. They said untouchability refers to the social disability imposed on certain classes of a person because of their birth in a specific backward class. Therefore, the word untouchability in Article 17 means caste-based untouchability. Second thing, Article 17 says that untouchability shall be an offence punishable in accordance with the law. So which law is it talking about? Because there is no law mentioned in the Constitution. According to Article 35, Parliament has exclusive power to make laws and prescribe punishment to offences under the fundamental rights. So using those powers, Parliament enacted the Untouchability Offences Act in 1955, which was amended in 1976 to make it more strict. Later, this act was renamed as the Protection of Civil Rights Act 1955. This law says a person practicing untouchability is punishable either by imprisonment up to 6 months or by fine up to 500 or both. and this article contains no exception. Last article of right to equality is Article 18, which talks about abolition of titles. Even before the country became independent, some people had certain titles like Raj Bahadur, Diwan Bahadur, Rai Sahab, Maharaja, Zamindar, etc. These titles were hereditary, that was never going to end, and were also creating inequality in the society. So it was very important to eliminate it. So Article 18 abolishing these titles gave four clauses. Clause 1 says all titles will be abolished except any military and academic title. It means title will be acceptable if it is given on the basis of merit like doctor, engineer, major, colonel, etc. Government of India also gives national awards like Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri. These are also titles. According to a landmark case of Balaji Raghavan versus Union of India, the Supreme Court said Article 18 abolishes hereditary titles and not titles given on the basis of merit. And national awards are given on the basis of merit, so it doesn't violate Article 18. But the awardees cannot use it as suffix or prefix with their name. Clause 2 prohibits a citizen of India from accepting any title from any foreign state. Clause 3 prohibits a person who is not citizen of India but holding any office of profit or trust under the state from accepting any title from any foreign state without the consent of the president. And clause 4 says no person, citizen or non-citizen, holding any office of profit or trust shall accept any title, present, emolument, or office of any kind under foreign state without consent of the president. Actually, clause 3 and 4 have been added to ensure that a non-citizen should remain loyal to the state. So we have completed all the articles of right to equality, that is from Article 14 to Article 18. In the next video, we will talk about second fundamental right, that is right to freedom, which is defined from Article 19 to Article 22.